Hello everyone, welcome back to the video lecture on intermediate paper number 5, Business Law and Ethics. Previously, we discussed chapter number 5, Indian Partnership Act 1932. As far as examination is concerned, it's a chapter which has less question asked previously. So, this is a video lecture where we will identify important concept and question from an examination point of view. It need not be so direct. It can be an indirect way of asking, but bare minimum, students are expected to know this much. So, first question is direct question. What is a partnership? A relationship between person agreed to share profit is called a partnership. The keyword is agreement to share profit. It can be a person acting for all or all of them acting together. Another direct question is, what are the essential ingredients for constituting a partnership? There should be an agreement between parties. The agreement must be to share profit or business. The business must be carried on by all or any of them acting for all. The existence of an agency between the concerned persons inter se. The agreement need not be in writing. It can be oral. It may be expressed or implied. These are the essential elements for a valid partnership. Different type of partnership: general partnership, limited partnership, partnership at will, particular partnership. General partnership, liability is unlimited. Limited partnership, liability is limited. General partnership, partner's liability is unlimited. Limited partnership, liability of partner is limited. Partnership at will, it is constituted for an indefinite period. Particular partnership, it is for a specific period. Another question can be different types of partners. Working or an active partner who actively work in the partnership on day-to-day basis. Sleeping or dormant partner, he does not take active part in management of firm, but simply constitute to the capital. Limited partner, liability of the partner is limited. Partner in profit means in the case of a profit only, that partner will be available. He or she shall not divide the profit loss. Yes. Nominal, ostensible or quasi partner, a partner whose action lead us to believe he or she is a partner. Minor as a partner is very important. A minor can be admitted as partner for gain only or profit only. A minor can be a partner for profit. Never can a minor be asked to share loss. Another kind of question can be partnership versus company. Separate legal entity, partnership not present, company it is separate legal entity. Liability is unlimited in case of partnership. It is limited in case of company. Minimum number of person, 50 in case of partnership. For a private company, minimum 2, maximum 200. For a public company, minimum 7, maximum no limit. A partner cannot transfer his shares without the consent of all members in case of a partnership. Transfer of shares in public limited is not restricted. The firm can be run by all or any of the partners. The board of directors are responsible in case of a company. The relationship with partner is that of an agency, no relationship in case of a company. The profit is distributed according to the agreement between partners. If no agreement, equal distribution. No requirement of profit distribution to members. It is at the discretion of the management to declare profit, that too only out of profits. The creditors of a firm can proceed against the partner jointly and severally. The creditors can proceed against only the company, not against the shareholders. This is a separate legal entity. Audit is not compulsory for partnership. Various types of audits are compulsory for a company. Firms can be dissolved at the event of death of a partner, retirement of partner, unless otherwise they are agreeing to an agreement. A company cannot be dissolved only by the winding up procedure of court. Difference between partnership and LLP. Separate legal entity not present in partnership. It is present in LLP. Liability is unlimited in case of partnership, limited in case of LLP. Minimum number of persons for partnership 50. No limit for LLP. Minimum 2, maximum it can be any number. Partnership is not a separate person. LLP is capable of entering into contract and holding in its own name. Partnership cannot. Compliance purview, partnership is less. LLP is more. Firm can be dissolved at the event of death of partner. LLP can be dissolved by complying with the provisions of LLP winding up dissolution rules 2012. Difference between partnership and Hindu entity divided family. Relationship between subsists between partners. It is a single person known as Karta. Cannot have a partnership by itself. All partners may involved in management. Karta or HUF is managing the business. Partners can share profit as per agreement. No sharing of profits in HUF. Properties here. Properties, even though in name of partnership, firm belongs to all partner. The business is a species of ancestral joint property in which every member of a family acquires property. Each partner is the agent of other. It has implied authority to contract debt and pledge that property and credit family for ordinary purpose of family business. Firm can be dissolved on the event of death of partner, retirement of partner, unless otherwise agreed in agreement. Death of Karta will not lead to dissolution of HVF. What are the general duties of a partner? To carry on business, to be faithful to all and other, under true accounts and full information of all things affecting the firm. Every partner shall indemnify the firm any loss caused by it for by fear of fraud. So, suppose a person act as though he is the partner, actually where he is not, and made believe third party that he is the partner and did any transaction. Later on, he cannot wash his hand and say he is not a partner. He shall be treated as if he is a partner. What are the event or in constitution of a firm? If there is any requirement for change in profit sharing ratio, admission of new partner, retirement of existing partner, death of a partner, amalgamation of two partnership firm. What happens if a firm is not registered? The possibility for a legal remedy will not be possible in case of firm, that is partnership firm, not registered. What all event a partnership firm can be dissolved by order of court. If there is an agreement between all partners to dissolve, it can be dissolved. If any one party of the partnership become insolvent, compulsory dissolution. Based on some contingencies, a dissolution can happen. But in the contract itself, it will be agreement itself, it will be mentioned. After the expiry of fixed term, the firm shall be dissolved. By order of court, a firm can be dissolved. When will a court order for dissolution? If any partner become in unsound mind, any partners become incapable of performing his or her duty, a partner is guilty for conducting business. Likewise, a court can also order dissolution. So these are all the important topics of the chapter. Thank you.